That was the scene outside the St. Louis Planned Parenthood, the only abortion services provider in the state of Missouri. Today, the United States came the closest it has come in nearly half a century to having a state with absolutely no access to legal abortion services. For years, the Planned Parenthood in St. Louis, Missouri has been that state's one and only abortion services provider. That facility was set to close today after Missouri's Republican governor, Mike Parson, announced that a state audit found what he called, quote, a number of serious health concerns, end quote, at the facility. The clinic, Reproductive Health Services of Planned Parenthood of the St. Louis region, says the audit's results were politically motivated and that the state had made unreasonable requests in order to try and force the clinic to close. In a ruling this afternoon, Missouri Circuit Court Judge Michael F. Stelzer ruled that the clinic would be able to remain open as the case works its way through the courts, writing that such a decision was, quote, necessary to preserve the status quo and prevent irreparable injury. This ruling comes just 1 week after that same Missouri governor signed into law a ban on all abortions in the state after 8 weeks of pregnancy, the latest in a series of restrictive abortion laws around the country. On Wednesday, Louisiana's Democratic anti-abortion governor, John Bel Edwards, signed into law a similarly restrictive ban on abortions after 6 weeks, a period during which some women don't even know that they are pregnant. This is all part of an effort by anti-abortion forces around the country to push the issue to the United States Supreme Court to try to get the court's conservative majority to overturn the landmark precedent in Roe v. Wade, which codified the right to an abortion in the United States. Earlier this evening, the former head of Planned Parenthood, Cecile Richards, joined my colleague Chris Hayes and issued this stark warning.
This is not a drill. This is no longer an intellectual question. Roe is absolutely at risk, and so is the health care and the well-being of millions of women in this country.
There is no way of knowing how the Supreme Court will rule on a challenge to Roe v. Wade, if it chooses to rule on one at all. But anti-abortion advocates are confident that this Supreme Court may be willing to overturn one of the most important rulings of the last 100 years. But here's the thing to consider. Regardless of where you stand on abortion, let alone the legality of it, Roe was not just a landmark case for abortion rights, but for American legal jurisprudence, and specifically as it related to privacy. So what would it mean for the future of our legal system, indeed our expectation of privacy, if Roe v. Wade were to fall? Joining me to help answer that question is Jeffrey Rosen, president and CEO of the National Constitution Center and author of the book, The Supreme Court, The Personalities and Rivalries That Defined America, and several other books on the presidency and the court. Jeff, thank you for being with us tonight. The decision in Roe was based on a broader understanding of the right to privacy as outlined in the 14th Amendment of the Constitution. So the question I have for you tonight is, what might the unintended consequences of challenging Roe because of one's belief about abortion, what could those unintended consequences be?
Well, you're absolutely right that Roe is based on a notion of privacy. It came from a case called Griswold versus Connecticut that recognized a married couple's right to use contraception. So in theory, that right could be at risk if any state wanted to restrict contraception again. But Roe was extended in cases, most notably the marriage equality case, which rooted its recognition of the right of all people to marry those whom they loved in ideas of privacy, dignity, and autonomy. So jurisprudentially, even the marriage equality cases could be at risk if Roe were to fall. But what's so significant about these recent challenges is that states like Missouri and Alabama and Georgia are now going a step further. They're saying that the fetus is a full constitutionally protected person from the moment of conception. And if the court, in overturning Roe, were to agree that states have the right or even the obligation under the Constitution to recognize fetal personhood, then a whole series of other laws and understandings could fall. People could be required to pay child support for unborn fetuses. It would be possible that a couple that used in vitro fertilization and destroyed an embryo in the course of doing that could be prosecuted for homicide. And even more significantly, a non-citizen who was pregnant, a woman, might not be able to be deported unless her unborn pre-citizen fetus had some kind of judicial hearing. So in other words, the consequences of recognizing fetal personhood in the law as being constitutionally protected could be very, very sweeping indeed. And that's why this strategy is so significant and really deserves our close attention.
So I'm way in over my head at this point, but I'm going to ask you about a quote from the 1974 decision, Mitchell versus W.T. Grant, that was actually quoted in the 1991 case, Planned Parenthood versus Casey, about changing established decisions or stare decisis established law based on the Supreme Court's makeup. The quote is this: "A basic change in the law upon a ground no firmer than a change in our membership invites the popular misconception that this institution," meaning the Supreme Court, "is little different from the two political branches of government. No misconception could do more lasting injury to this court and to the system of law, which is our abiding mission to serve." This was written in 1974 for a decision. It was quoted by O'Connor, Kennedy, and Souter in 1991. Does this still hold?
Well, it's a concern of many justices, most importantly, the Chief Justice of the United States, John Roberts. He is very concerned about institutional legitimacy. In a decision last year emphasizing the importance of precedent, he expressed concern that citizens might think of the court as political if its decisions change based on its membership. And he has embraced the same three criteria that decision you cited, Casey versus Planned Parenthood, used in evaluating whether decisions should be overturned. First, has society come to rely on them? Second, have facts changed? And third, has the decision become unworkable? And those are the same considerations that he would weigh now. The conventional wisdom, for better or for worse, at the moment is that the chief is not eager to hear cases that would directly challenge Roe. That's why just this week the court unanimously refused to consider a challenge to the heart of an Indiana law that restricted sex selection-based abortion. So an institutionally minded chief has also persuaded Justice Kavanaugh in a case involving admitting privileges at hospitals to vote against hearing the case because he does not seem at the moment to be in a rush to overturn Roe. But what's so significant about this debate is that the states are making it harder and harder for the court to duck this question by embracing these broad claims about fetal personhood that, as Justice Blackmun in Roe himself acknowledged, strike at the core of the reasoning in Roe v. Wade.
I've got 30 seconds left, but I want to ask you, does the issue of whether a justice thinks a case in the past was, in their opinion, wrongly decided come into play here?
Yes, those three criteria apply even if a justice thinks a case was wrongly decided, as Justice Kennedy and Justice O'Connor and Justice Souter may have done when they upheld the core of Roe v. Wade. They're still not supposed to overturn that case if society has come to rely on it, if the facts haven't changed, and if the decision isn't unworkable. So those are the three criteria, and they're going to be hugely important, along with this overwhelming question you've identified, so important, Ali, of the Chief Justice and his concern about institutional legitimacy.
Jeffrey Rosen, it is my pleasure to see you tonight. Thank you for joining us.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.